and welcome to the farm. Two very interesting developments on the show this week. In a weekend rescue mission, the Delhi High Court saves pledged promoter shares of Unitech from going on sale. And the Balco Arbitration Award once again throws up the vexed issue of call and put options. Are they legal or illegal? Before I say anything further, let me introduce both my guests on the show tonight. I have with me Bharat Vasani of the Tata Group and Berjis Desai of JSA. Gentlemen, thank you very much for joining me. And now let's get on to new things first. This is surely new, as most lawyers tell me. For the first time, it seems the High Court has stepped in to stop the invocation of a pledge, that too via an ex-parte injunction handed out on a Sunday. The matter at hand pertains to Unitech, whose promoters, or a promoter company, had in fact raised 178 crore rupees via unlisted, unrated, secured, redeemable, non-convertible debentures and offered Unitech shares as collateral. On Friday, January 28th of this year, Unitech's stock price dropped a few percentage points to 51 rupees. Now, while that in itself was not calamitous, it marked a 40% decline in the company's stock price since November 2009, triggering an event of default. And so, at 9 p.m. or 13 minutes past 9 p.m. that day, the debenture trustee informed Unitech's promoters that it would be selling the pledged shares worth over 400 crore rupees apparently on the next working day, which happened to be Monday, as this was a Friday. The promoters then made Delhi High Court Judge Sunil Gore work over the weekend. The judge found the prima facie case, said balance of convenience is in favor of promoters as they had offered to pay the entire amount, and that if a stay is not granted, the promoter would suffer irreparable loss, and hence granted the injunction, or in simple words, blocked the sale of those shares which served as collateral. Good for them, I guess, but not so good for the concept of raising money via pledged shares. Or so says Berjis Desai. Berjis, why do you believe that this judgment comes ex-parte injunction, not judgment, comes as a setback for this whole process of promoters pledging shares to be able to raise money?
First of all, as you said just now, it's only an ex-parte ad interim order, so it's not a judgment.
Right.
And it doesn't lay down any law. And the judge is prima facie satisfied that a case existed for injuncting the trustees from selling the listed shares.
Right.
The question is, forgetting the facts of the present case, this raises a larger issue that promoter financing is being done regularly in this manner, where the promoter companies issue debentures, which are usually subscribed by HNIs, and to secure the obligations under those debentures, the shares of the listed company are pledged. Now, if usually the share pledge agreement, as in this case, categorically provides that if an event of default occurs, in this case the share price fell to the stipulated level.
And there's no dispute over that event of default,
There cannot be a dispute because it is not subjective, it's an objective event of default. So in such a situation, the trustees had a right immediately, forthwith, without reference, without notice to the promoter, to sell the shares.
And this was laid out in the share pledge agreement.
That's correct. However, of course, considering that Section 176 of the Indian Contract Act provides that you have to give a notice before you sell the pledged item, a notice was given by the trustees, but it was assailed in the suit that this is not reasonable notice.
The notice was given at 9:13 on a Friday night, saying that they will sell shares on the next working exchange day, which would be Monday.
That's right. As I said, without going into the facts of this present case, it goes on further to say that even if it was reasonable notice, selling the listed shares of such a large quantity in the market would be disastrous for the other public shareholders of the company, and so on and so forth, and therefore an opportunity should be given to rectify the event of default. In this case, of course, there was no question of rectification because the price had fallen. But the fact is that if this becomes a trend, and if courts start injuncting the invocation of a pledge and the enforcement of a pledge, all promoter financing of this kind is going to dry up, because the HNIs who subscribe to this obviously did it on the strength of the security cover of 2.5 times or whatever it was.
Yes, it was 2.5 times
of the
security cover.
And if you find that you do not have an easy exit remedy, The other two remedies are post-dated checks issued by the promoters as well as by personal guarantees of the promoters. We all know how long that takes to enforce. So the sale of the shares was the only easy exit security, and if that is going to be throttled, then that's the end of the marketability of these type of instruments.
But to be fair, and as the promoters themselves have argued in front of this judge to be able to get this ex parte ad interim injunction, they said we've never defaulted on an interest payment. Whenever the security coverage ratio dropped below the mandated 2.5%, we've always topped it up within the required period of time. Even in this case, when we were told on a Friday that, you know, an event of default has occurred and you intend to sell shares, we tried over the weekend to get you guys to see reason and say no, but we will make whatever is required to meet prepayment. We've laid out a prepayment schedule over the course of the next month to ensure that we prepay the entire debenture facility. Why would you then cause us this kind of harm by going and selling almost 400 crore rupees worth of promoter stock in the market in one go, which would, you know, cause, as in their own words, catastrophic impact on the stock price of Unitech as well as on retail shareholders? Now, isn't that a fair argument to make? If you are willing to make good the damage, then why can't somebody have the patience?
See, I think it's a question of the sanctity of the contract. You are agreeing with the debenture trustees that if a particular event occurs, and this is, as I said, a very objective event of default, then there would be an immediate remedy and a right given.
Right.
On the basis of that, the bargain is struck and the monies have been entrusted to you. Now, when things go wrong, you cannot seek to upset the sanctity of the contract. You should have thought of this before. The share price didn't fall 40% from the issuance price in one day. It was slowly eroding. So if at all this fear or apprehension was there, security could have been voluntarily topped up. Or a dialogue initiated with the debenture trustee
in advance,
much before a potential event of default like this, if this was the apprehension. But that was not done. And look at the situation of the debenture trustee. The debenture trustee is caught in the crossfire between the interest of the debenture holders, which he has to protect, and on the other hand, he has to exercise this power, which is a very maybe an unpalatable exercise, but he has to do it. So if he does not invoke the pledge and if he does not sell the shares, the debenture holders are going to go after him and say that you are not discharging your duties as a debenture trustee.
So what do you think